Great. Thank you, Taylor, for that introduction. And thank you all for joining me here in the lunch hour to go over this EEO material. It is an overview. Audience, I believe, here is mostly federal employees, certainly those that may be interested in understanding his or her rights in the federal context. Some of these concepts do translate, of course, to the private sector context as well. However, most of the laws we'll be discussing and just a broad overview does apply to federal employees. A little bit about me. I've been working here with the law firm for a number of years, over 10 years, doing this type of practice. I do MSPB work as well as EEOC work and a number of other administrative as well as federal and state court litigation. We can move on. So as I briefly mentioned, what we're here to discuss here is an overview of laws that protect employees in the mainly discrimination in the workplace, spotting discrimination issues, timeliness of bringing forth such issues, what to expect after filing an informal complaint, and then what to expect after the formal complaint process ensues, and finally how to approach ADR and alternative dispute resolution avenues to redress various EEO complaints. We can move on. So when we're talking about EEO, what is it? Equal employment opportunity. We're talking about Title VII, namely of the Civil Rights Act of 1964. It's really the juggernaut law that has advanced discrimination laws in the workplace. It's did over time through Congress over the years. Broad categories of protection: race, color, national origin, includes ancestry and ethnic characterizations there, as you see. Sex, to include pregnancy and gender stereotyping. Religion. We get into age statutes, Age Discrimination of Employment Act for protections of employees 40 and older. Rehabilitation Act of 1973 protects those with disabilities as defined pursuant to that act. Covers people perceived as disabled as well as actually disabled. And also a record of disability that I believe is in a subsequent slide. We can continue. More recently, the Genetic Information Discrimination Act of 2008. We also will discuss retaliation. These statutes that are referenced generally have an anti-retaliation provision built into those statutes. Generally speaking, it is illegal to retaliate against someone because they have engaged in protected activity, right? And that is legally defined. Two types of protected activity in these circumstances generally are an opposition clause and a participation clause. So opposing unlawful discrimination in the workplace, right? You are maybe telling your supervisor that you don't appreciate racial epithets being used at work, right? That would be an opposition to some sort of unlawful activity in the workplace. There are protections associated with that type of opposition activity. More frequently, you see participation activity. You go to a mediation and thereafter you are reassigned or you're demoted or bad things start happening to you at work. Potentially there's a retaliation provision or retaliation cause of action that is triggered by basically a connection there, a causal connection that can be either inferred through by time or maybe expressly stated depending on the context of a specific fact pattern. So, participation is also protected under the law in any of these statutes that were referenced. All right, next slide. Discrimination based on race. So racial discrimination, as one can imagine, involves treating someone different because he or she is of a different race or because of personal characteristics associated with that race. It's noted here, such as hair texture, skin color, or certain facial features. Color discrimination involves treating someone differently because of skin color or complexion. So that would also be protected under the law. Just because someone is of a different racial profile doesn't mean you don't have a cause of action. There are fact patterns, and it's certainly courts and the EEOC has upheld rulings in which members of the same race have treated each other or, same racial classification disparately despite being of the same race. So that doesn't necessarily prohibit any kind of claim. They call these racial stereotyping fact patterns. So. All right, we can move on. Discrimination based on sex. This is a wide classification here. Really, the crux of Title VII litigation in the early years involved sexual harassment fact patterns, and then the law evolved. But sex discrimination involves treating someone disparately because of a person's sex. Can include gender identity because or sexual orientation. Sexual harassment, that's prohibited under law. Again, harassment because of one's sex. This includes unwelcome sexual advances, requests for sexual favors, and verbal or physical harassment of a sexual nature. Sexual harassment is illegal or unlawful when it is frequently severe or pervasive in the workplace. And it creates a hostile or offensive work environment. So, certainly you don't need to have such concrete personal actions of being fired or demoted. I mean, just the offensive nature of having, being subjected to such a work environment rises to the level in which, such conduct could be determined unlawful. The law doesn't prohibit simple teasing, offhand comments, or isolated incidents that aren't very serious. That is true. That's something that the courts in any kind of case, whether that be an EEOC administrative case, which ultimately these matters are heard before, or also potentially federal court, a judge will be reviewing that standard. Are these things something that is hostile and an offensive environment taken in totality, or is this basically offhand comments? Or isolated incidents rather. So that's something that the trier of fact will be determining whether or not those, which of the two it's more kin. So, Title VII is not a general civility forum. That is true. However, again, when these things are viewed in totality and they alter a term or condition or privilege of one's employment, then they are in fact, unlawful. Harassment is unlawful when it's based on other protected categories as well. That is true. Harassment has developed not only in the sexual harassment context, but any of these other protected classifications that were mentioned: race, national origin, religious affiliation, disability status, age, prior activity. If they get to that level where they are changing the terms or conditions of employment, then that conduct is in fact unlawful as well on those bases. Next. Disability discrimination. Disability is defined as a physical or mental impairment that substantially limits one or more life activities. And then subsets of that information, or rather that cause of action, are a record of physical or mental impairment. So the employer hypothetically is not discriminating based on a known disability, but rather a record of such a disability, then that in fact would be unlawful. These are certainly more narrow subsets of disability discrimination. The other one here is an actual or perceived impairment. So if the employer is targeting an individual based on a perceived disability, despite the fact that maybe that employee does not have a physical or mental impairment, that substantially limits one or more life activities, then that conduct could potentially be unlawful. Next. This is an area that we often see here at the firm is reasonable accommodation issues. Generally speaking, an employer is required to provide reasonable accommodation to an employee or job applicant with a disability, unless doing so would cause significant difficulty or expense for the employer, an undue hardship. Okay, so a threshold question is whether the employee can perform an essential position, functions, the essential function of the position with or without accommodation, right? So that's sort of step one. And then there is an interactive process component of, assuming yes, assuming either with or without accommodation, the employee can perform his or her essential functions of the job, then if the employee determines a reasonable accommodation would be effective to perform one or more of those functions, then really those two parties, the employer and the employee, engage what's known as the interactive process. It's a good faith effort. The employee does not necessarily need to raise the issue if there is constructive knowledge on part of the employer that the employee needs such an accommodation. And then really a dialogue ensues. An employer is entitled to ask for medical conditions in response to accommodation requests, and that's true. So there's, obviously the medical accommodation, the medical disability drives the accommodation process. And that's something that is, certainly something that should be discussed during that interactive process so the employer can properly identify effective accommodations. It's not something that the employee gets to pick, right? You see that fact pattern more than once. I have a disability and it's generalized anxiety disorder, and I want 100% telework. Well, your doctor could maybe opine to the fact that that is necessary for the scope or nature of your work. However, if there are workarounds, you could come in to work, say, on a different shift or, within 410 schedule, that extra day off, would relieve some of that general anxiety to the extent that you could perform your essential functions. Or you can think of a myriad of different options. Maybe it's segregated office that could help you focus more with such a condition. But the point being is the employee doesn't get to pick an accommodation, but nonetheless that accommodation needs to be effective under the law. So really that's what these parties are aimed to determine when they're going back and forth. A bit of an affirmative defense. I mean, the employer can raise an undue hardship argument. It is more difficult in a federal employment context when you're talking about, these agencies that have millions, if not billions of dollars in taxpayer resources to show that, special lumbar supported chair would be unduly restrictive as far as their budgetary line items, right? So you don't really see that too much as far as an economical point. I mean, certainly if you're in a private sector situation and you're dealing with, mom and pop, grocery store, maybe you'd have more of those defenses. But, generally you're talking about effectuating really the product, you're dealing with mission related issues. If there is an undue burden, we're dealing with government contracts here and there is required face-to-face here. So therefore a complete telework situation would, potentially limit our ability to work with this contractor or something of like, I don't know, you could think, obviously we're talking with, various employees with missions out there, but, the point being is you may see something, you might see justifications that a position requires something that runs afoul with the requested accommodation. So you do see those issues raised. But really sort of the crux of the process is really determining once a disability is identified, which is certainly liberally construed under the law, and what is an appropriate accommodation. So you see quite a bit of discussion in that portion. All right, we can move on. Discrimination based on religion. So there's two components here, similar to any kind of Title VII bases, right? So you have prohibits discrimination based on religion. So that's a disparate treatment type of analysis. You're being targeted because you have a specific religion or religious beliefs, right? And then there's a sort of corollary component that tracks to some extent the disability analysis, right? Then there's a reasonable accommodation provision if the employer's mission in this case runs afoul of an employee's sincerely held religious practices, then there is that same dialogue that should ensue to hopefully address the employee's ability to engage in religious practices. So don't see these cases all that much compared to disability cases, but certainly they still are out there, and the EEOC hears a number of them a year. We can move on. So steps to consider before filing an EEO complaint. So I think that that's probably really the purpose of this webinar. You might be at work, you might be having some suspicions as far as treatment, of how, management is, targeting you or treating you differently, disparate treatment, right? So, there is that, and it kind of dovetails into the second point, the difference between discrimination and universal jerk. Fortunately, there's no law, at least in the EEO context that we're here to discuss today, as far as bad bosses that act, with questionable business practices in mind, fail to maybe advance the agency's mission, subjectively, or potentially even objectively, right? I mean, there's no law that the EEOC is going to force for hiring bad managers they're not a personnel agency. They're not going to act as OPM, or the Office of Personnel Management, right, to necessarily take action against bad bosses. In fact, they have no jurisdiction to do so, even if you win your case. I mean, they can request trainings and things like that, or there can be postings as far as findings of unlawful discrimination or suggestions that maybe a manager be disciplined. But at the end of the day, there's no authority for the EEOC to, heavy-handedly come into an agency and remove the bad actor. So when you're thinking about these things, definitely identifying the bases is paramount, right? Why am I being treated disparately? Why are things at work rougher for me than others? And if you start thinking about how your colleagues are treated, and again, their immutable traits in the workplace: race, sex, national origin, religious affiliation, disability status, age, or prior EEO activity, and you're starting to draw distinctions because of one or more of those factors, then yeah, you should be definitely thinking along EEO grounds. Familiarize yourself with what you need to establish and successfully prove a discrimination claim. I mean, at the end of the day, we can talk about how these things are proved. They're done through a long sort of statutory framework that's known as the McDonnell-Douglas framework. It's a burden-shifting framework that involves you, the employee, showing a prima facie case of discrimination. Ultimately, that burden shifting back to the agency to show it had, or at least proffering legitimate business reasons for its actions. And then finally, you as the employee showing pretext that no, these reasons that you're offering, employer, are not actually grounded in fact. And the real reason is discriminatory animus of one or more of these bases, right? So that's how these things are proven, as far as the legal structures considered. But in reality, what basically boils down to, you have your reason, right? It's going to be race, sex, national origin, religious affiliation, disability status, age, or reprisal, and you have, that's your theory, and then you have your personnel actions that are happen, right? I was demoted on this date. I was subjected to a hostile email from my supervisor on the next day. Supervisor showed up at my house and wanted my government issued computer and put me on administrative leave, whatever the issues are. You have these personnel actions that file some sort of chronology, and you have a bases. And at the end of the day, you need to show that these bases, are more likely than not the motivator of these issues, and not what the agency is saying. Agency saying, no, we're actually, demoting this employee because he was a poor performer. He was disclosing trade secrets to the Chinese, whatever the case may be, and you're fired because of that. It wasn't anything to do with your race, sex, etc. So, a judge, a trier of fact, ultimately a jury in a federal court case, if there is a jury trial, is going to weigh those two issues. Issue is really going to be paramount, and that's what these cases really hinge on, is causation. All right, we can move forward now. So you think you have a subjective belief you're discriminating in the workplace, what's next? Well, under federal law, if you're a federal executive agency and you're moving forward with taking action, the first step is contacting your EEO counselor. All agencies have requirements to post notices in the federal workplace as far as what to do, and you feel like you're being discriminated against. That information is available online through the MD 110, the Civil Rights Office, et cetera. So there shouldn't be an issue about finding your counselor. They should be, it should be publicized. You need to contact that counselor, and you need to contact that counselor sooner than later. There is a rigid deadline here, relatively rigid. I mean, we can talk about there are some workarounds. I mean, that the law has acknowledged, but at the end of the day, there's a 45-day deadline here. So if something bad happens to you at work, you have the subjective belief, really imparted on you by law. I mean, these things happen to you, and at that time, really the clock starts tipping, and you have 45 days to contact the counselor and make notice of, that incident. So last Monday, I went into office, my supervisor slid across the desk and noticed a proposed demotion. Okay, I think that's discriminatory. I want to start an EEO case. Okay, that's fine. Even a week later, I was actually demoted. Well, that triggers the actual effective action. That's an actual personnel action. So that's, that certainly puts you on notice of going to the counselor. So you need to be cognizant of these deadlines. They're unforgiving. We so often have sympathetic employees that come in on day 90 that, had bad thing, were terminated 90 days prior, and they're just out of luck. There's nothing we can do at that point. So, yeah, deadlines are real, and you need to be cognizant of them. The law requires it of you. We talked about the bases in some depth. All right, we can move on. All right, so meet the counselor, you initiated that first meeting, you have some sort of exchange. I mean, certainly the firm's practice is to document these things because there is a requirement that you would exhaust your administrative remedies and counseling. What does that mean? It means that you can't just raise other things later, right? Later in the formal process or in litigation that happened to you if they weren't properly addressed in counseling. So then, you see from time to time the issue where client comes in and you're months down the road and you get an acceptance letter at the formal stage of the case and there's claims missing, and then you say to client, well, didn't you bring this up to the counselor? Yeah, I brought it up. We talked about that demotion. Well, where is it? How do I prove that? And I just told him that. Okay, and then the counselor has his or her report that's devoid of any kind of reference to demotion. And now you're in that position where you're arguing to an adjudicator, hey, listen, this claim should be involved in the case. It was exhausted during this phone call on this date. We have a record of the phone call. The client can attest to that. But ultimately, is it something that's going to be accepted? It's a judge's call. And you want to avoid those things, right? You want to avoid things that are simply discretionary on a judge when you can, you can memorialize a record and do better. So, I guess that's one reason jumping ahead to hire a lawyer. But anyway, that is something that to keep in mind. Suppose I digress to some extent, but here we are at the counseling phase. We jumped on board. You're talking to the counselor. You're going to be presented an option. You want to go through traditional EEO counseling, or do you want to go through ADR, right? They're different conceptually to some extent. The traditional counseling does not involve mediation, so there's no formal sit down with management to hopefully address your issues and resolve them early on. Rather, the EEO counselor generally acts as a liaison between management and the employee. So there's pros and cons to that, but generally it's a quicker counseling phase. And alternatively, with the ADR, you have a 90-day complaint phase, and that's attended generally through a mediation process where there is a mediator, agency appointed mediator, and management to sit down to hear your claims and hear your grievances, generally as noticed to the EEO counselor, and hopefully resolve them. It's another benefit of having a well-documented chronology up front prior to that mediation, so everyone knows what your claims are about, what your bases are about, and what you're claiming is unlawful conduct on behalf of the agency. Mediation is The goal is the compromise, right? It's a compromise between both parties. Both parties aren't going to walk out with everything that they want, and certainly a good mediation. There's compromise on both parties. That's the definition. I mean, the agency understands that, especially if you hire a lawyer, that you are well prepared to move forward with your case. You have a chronology that documents the accepted bases, the proper bases and proper harm, whether that's concrete harm or hostile work environment that's unlawful. So, there's a proper documentation. So they're interested in hearing what's going on. And at the same time, the client needs to be aware that these cases take long and they take years, right, to go through an adjudication from a judge. And certainly if you hire a lawyer, there are significant fees associated with that. So, the client needs to be prepared to compromise as well. So both parties need to compromise and hopefully, meet a middle ground earlier on. I will say that, probably statistically it doesn't happen there because, honestly, there's no record of evidence, right? There's simply allegations. There's no record that's developed. So, mediation is a good preliminary opportunity to sit down and have a discussion to see if there are the points of discussion with the agency, and hopefully your case would resolve at that juncture, but it's certainly not your only opportunity to engage in negotiations or even have a subsequent mediation. So anyway, that process happens within the first 90 days or so. And then if there's no resolution, then the case moves on. It's done through what you see there in the bottom point. A notice of right to file a formal complaint is issued. And once that occurs, you have 15 days to go ahead and make the election whether or not you want to file a formal complaint with your agency. All right, so next. Okay, we got to the end there. So, yeah, I mean, just I can summarize briefly, the formal complaint phase is an investigative phase. Once that complaint is filed, the agency has 180 days to basically come up with a report, right? It's not a report necessarily of a finding of discrimination. It's just a report. And that will include testimony from you, the employee, as well as management that's been involved in the allegations, right? So, it's really the sort of the agency's legal requirements under the law to administratively address these cases, the informal and the formal complaint phase. And then if you elect to take other action, it's going to be through an outside party. You have the opportunity for a final agency decision, of course, at the end of that report investigation. And the agency can make a determination on the merits. However, just more generally, it's the EEOC. That's an independent body that would begin hearing the substance of your case from really an independent prism as far as a judge. All right, covered some ground there. I thought some questions come in. I don't know if I can find them here, but I'll look for them. And I don't know. I think there were some pre-submitted questions too. Let me try to find them.
And if anybody has any questions for Ryan, please submit them via the chat so I can send them over to him. Thank you.
Okay, we got some here. How does a complainant use witnesses during an EEO investigation? Well, witnesses are just that, right? They can be eyewitnesses, hearing witnesses, whatever the case may be, to situations that may have occurred in the workplace. The best practice is really at the formal investigation, if possible, identify them for the investigator, right? I mean, the ROI, unlike so many other civil contexts, are really a helpful aspect for complainants. I mean, it's free discovery essentially. So if you're able to identify that witness to an investigator, that invest and proffer exactly, why that witness is relevant. And that's sort of another issue that we see quite often with, persons without legal knowledge. They just want to, identify people that are sympathetic to their cause, or character witnesses, right? An investigator likely is not going to interview those people, but if there's a factual issue in play, you get back into the racial epitaph sort of hypothetical generally, you heard it in the workplace, you opposed that conduct right there, right then, and, Jane Doe was standing next to you, and you know Jane Doe heard what you said and she acknowledged what you said, then that would be certainly someone you want to identify in that context so they could add credibility to your statement, because inevitably you're going to get back that ROI, and that manager's not going to state that, that management through the agency counsel, right? They're vetting witness statements as well, generally. So what you're going to hear there is, oh, I don't recall that, or that's not the way that context, that's not the way that that fact pattern arose, or that factual circumstance. And you want to, have that witness to corroborate your version of events. The way to do that is to identify that early on, and, get a statement, sworn signed statement in that ROI to add credibility to your claims, right? So, again, I guess the thought on witnesses, you generally see, clients come in the door, and something, again, that's appropriate for the lawyer to educate a client. They come in the door and they, identify 55 witnesses, and they're all, marginal relevance just because they want to talk about credibility and how good of a worker a client was. That might not be helpful, but helpful witnesses are, hugely important, because they're going to add credibility to that general proving structure that I outlined earlier, right? The agency's reasons are wrong and my reasons are right, and here's my reasons. Here's the reasons why I do believe it was opposition, this fact pattern, a reprisal for opposing discrimination, and here's my witness to corroborate it. So, yeah, I mean, witnesses are huge. I mean, the agency, of course, oftentimes has the value of many witnesses, because I think we all understand in the workplace dynamics, managers often align their stories with one another, whether that is premeditated or not. That's another issue, and that's something that you can delve into in discovery as well. But you often see supervisor 1 through 3, first level supervisor through third level supervisor line up and provide relatively similar statements until pressed with additional questioning. So agency at a hearing or whatnot is likely going to parade in witnesses 1 through 10, while oftentimes it's just the complainant, right? It's the complainant's account. And, a judge looks at that. If you have 10 witnesses that have the same story and you just have a complainant telling a different story, then, again, it gets to that pretextual component. More likely than not, the judge in that case is going to side with the agency, right? So the more that you can help corroborate your story, the better ultimately, generally see these cases suss out. Can I come up with a list of colleagues to interview to support my claim of discrimination? I mean, you can come up with them. Yeah, I mean, you're free to interview them. I mean, certainly, she'd be tactful about it. If you're working on a big project, and you barge in to talk about your EEO case, and the last thing you want is have some sort of conduct unbecoming or some sort of circumstance where you're facing discipline. But yeah, I mean, generally, you can certainly interview people. If you're a pro se complainant, and lawyers do that, right? I mean, you identify individuals, we reach out on your behalf to interview witnesses. There are boundaries with that, of course. I mean, I can't just call up generally, the RMO of your case and say, hey, let's chat, right? I mean, that wouldn't be appropriate. There's avenues to do that, but it's not generally not in such a normal context. All right, we got anything else? Beyond mediation-free ADR, how can a peer review panel or fact finding from a group of experts be used effectively in the ADR process and the formal complaint process? It's really tough to say without knowing like facts of a case, but you're not going to generally call any experts in the investigation. Again, it's an agency sanctioned investigation. There's rules to it. I mean, the agency needs to make a fair and impartial report for which a fact finder can make such a determination, whether discrimination occurred in the record. But you'll be, sorely disappointed if you expect them to, interview your expert or something like that. They're not going to do it. So, that comes later. Certainly, lawyers interview experts. We can identify experts depending on the facts of the case. I've represented hundreds of federal employees at this point, and very, very rarely do you need an expert. I mean, if it does help the judge to some extent, you can identify experts. Generally the expert comes in the form of a medical expert, i.e. a doctor, right? I mean, there's damages associated with cases. So to the extent that a doctor can opine about those things, that would be a helpful expert. I addressed sort of the credibility issue. What is the process if you are appealing a decision? Well, there needs some sort of conclusion as far as a final decision. That can take different avenues. As I mentioned briefly, once you receive that report of investigation following the formal complaint, you could request a final agency decision. You know, that's certainly the quickest option. Statistically, I think they're about 2 or 3% successful. So, you know, there is that. I mean, we rarely recommend a final agency decision, but you know, you can go that route. It gives you a final decision, and then the appellate process from there is right to the Office of Federal Operations. It's the EEOC's appellate arm of its agency. So that would be one avenue to get to an appellate decision. More commonly, you file a hearing request following that report investigation. That process ensues. You have opportunities to engage in things like written discovery. There will be motion practices, practice where most commonly the agency files a motion asking the judge to dismiss the case. It is your burden of proof. You do put on a showing that there are facts at issue that warrant a hearing, and assuming that you're successful there, you get to a hearing, and then a final decision is issued following a hearing. That decision could be again appealed to the Office of Federal Operation. If your case is dismissed on summary judgment, again, judge finds no material facts warrant a hearing, then you can appeal that decision as well. Again, that goes to the Office of Federal Operation. And after this entire administrative process, if you're not happy with that result, you can seek redress in federal district court. I had some general comments here, sort of a low evaluation, and you've been getting outstanding evaluations. I mean, you see that fact pattern quite frequently. Again, it's fact specific. I can't provide anyone here any legal advice, but it ultimately depends on sort of the background of the circumstance. I mean, if you had the same supervisor for 10 years and all of a sudden you got a low evaluation, it's going to be difficult to prove discriminatory animus, right? Because again, your supervisor had knowledge, constructive or otherwise, of your immutable classifications: race, sex, national origin, religious affiliation, disability status, age, or prior activity. So it's going to be difficult to prove that. Now, more often you get a new supervisor that transfers in and there's issues in the workplace, and the prior fiscal year you're rated outstanding and then you went to minimal or something like that. But again, ultimately the proving structure doesn't change, right? So you're gonna have to show that comparators outside of your protected classes with similar performance were treated more favorably, i.e. given higher performance reviews, or alternatively, there could be some sort of direct evidence of discrimination in the workplace. Maybe that's through comments or something of the like. I mean, there's some things that I addressed here. Can a complaint be filed when something adverse happened 9 years ago? Not in the EEO context. That's way outside of 45 days. There's a question sort of involving good faith negotiations. I mean, it's a nebulous context. I mean, you think there'd be more substance to that term, right? I mean, generally when a parties agree to engage in negotiations, it is in good faith. It's written in not only attorney ethical rules, but it's written in sort of the context of the MD 110. But really the threshold is very low. I mean, coming to a settlement table and listening to the other party is arguably good faith. So there's very little enforcement you can do there. I mean, you can see good faith if they say the agency provided you a concrete offer, right? I'll provide you X amount of dollars, and I will provide you a reassignment within 2 weeks, and this, that, or the other. And then, that offer is conveyed. The mediator memorializes that offer, and then maybe 2 days later, it went up the chain, and some high-level colonel said, "No, I don't like that idea. Let's just revoke it all." I mean, potentially with something more tangible on paper, and then, situation like that, then, potentially you could at least make that argument, or at least a colorable argument. I don't think it would necessarily gain too much traction because, again, voluntarily, settlement is voluntarily at its core. So both parties need to agree to a compromise. And that's generally done when pen hits paper and the agreement is fully executed. So just because a party is not offering you the relief you believe your case deserves, certainly not a breach of good faith. That's basically all I have here. On these notes, let's see, check. Okay, I think I hit everything unless someone has something to close us out. Okay. Taylor, you with us?
Yes, I'm still here. A lot of the
Okay.
questions that are being submitted are super specific to your case. So I don't think Ryan will be able to answer some of those. If anybody does need any further assistance, feel free to contact the firm. Our contact information is up on the screen. I just want to thank everyone for joining today's presentation, and thank you, Ryan, for presenting. I hope everyone has a good rest of their day.
Thank you all. Have a good day.